하겠습니다. Hello everyone, thank you for joining us today at the second seminar of Asia Pacific Arbitrators Forum on this early morning. My name is Kim, and I'm the Deputy Secretary General of Asia Pacific Arbitrators Forum, and we'll be introducing our speakers and, if necessary, partially translate words in English today. Today we have 3 guest speakers today, and we'll be delivering their presentation in the order of first, Daejeon University Professor Kwon Young-an, next, lawyer Mina Kim, and lastly, President Seung-Yeol Kim. Each speaker will be presenting for about 15 to 20 minutes for his or her presentation. And after each presentation of 3 speakers, there will be a Q&A session. First, I would like to introduce President Seung-Yeol Kim, who is the President of Asia Pacific Arbitrators Forum, and he will be delivering the opening speech for us today. Please give a round of applause and welcome Mr. Kim.
Good morning. Thank you for participating in this seminar, even if it's a very early morning. And also, today is the coldest day in this year. I'm very pleased to have a second seminar with the Asia Pacific Arbitrators Forum, which will be conducted in English. Even if you are just all of the Koreans, but because you are just targeted the global market, and therefore it will be conducted in English. Today's topic is very quite interesting and very important issues. And the hard issue is the ODR process, which will be just delivered by the Professor Anguna, who is one of the leading authorities in ODR system. And also, we are very interested in the Chinese market, and especially ADR and the arbitration industry. But we are focused on the dispute in the entertainment business. The speaker is attorney Mina Kim, who is a former legal counsel for the SM Entertainment, and who is very specialized in this kind of dispute and ADR resolution process as well. And also recently I visited the ICC, and also I had to spend some hours with the managing counsels about the internal process, especially she is put some emphasis on strict security process to enhance the credibility of the arbitral world. And today's topic is very timely, and at this stage very important issues. And I sincerely hope and believe that this seminar session will be very productive to all the participants, including the speakers and participants on the floor. Would you please enjoy this seminar sessions? Thank you very much.
Thank you, President Mr. Kim. And now I would like to pass the mic to President Seung-Yeol Kim, as he will be leading the discussion panel as moderator today.
Yeah. I'm just this is for me. This is not familiar with you, but it's normally this kind of some panel tables, and but just because of the reasons, and we are not able to format this panel tables, but I'm acting as a moderator, and I just as I mentioned before, just the speech will be delivered by Professor Kwon Young-an and attorney Mina Kim, and later on me, and then we'll have some total Q&A sessions. And would you join us in giving a warm welcome to Professor Kwon Young-an? Please.
Good morning, everyone. My name is Kwon Young-an. I'm teaching all kinds of international practice and law at Daejeon University. Before I moved to Daejeon University, I used to work at the Korean Commercial Arbitration Board, just this office. And that's why I'm quite a little bit nervous, because I made a presentation at this inauguration seminar last July, August, at 39th floor. But this is the 43rd floor, just at the opposite side. There is a KCAB office. It's such an honor to make a presentation before a distinguished guest. Today's my topic is ODR, it's an online dispute resolution. As you know, time goes by, and as you know, e-commerce is radically changing the trade patterns of all economies, establishing international trade through the sale of related goods and services by bringing together in a virtual place traders and consumers around the world. Actually, this presentation was made at the second workshop of Economic Research Institute of ASEAN and East Asia in Bangkok last July. And this is a sort of like abstracted version. And the working paper will be published by the end of this year. So if that working paper will be published, I will circulate for your better understanding. Probably, as you may imagine, online dispute resolution is the hottest issue in international community throughout the world. So everybody talks about ODR. And I think ODR will change the rule of game of dispute resolution among those arbitration and ADR institutions. And also, it will change the pattern of your business as a lawyer. Because when I studied and researched on this part, I found that I felt it's a little bit confusing and very scary that I cannot imagine how this ODR system will change the regime and picture of dispute resolution. So I will briefly introduce three subjects today. First one is what is going on among international institutions dealing with this ODR system, especially consumer protection from the disputes arising out of e-commerce. And then I will suggest of some ways to adopt an effective ODR system in Korea, very briefly. According to the survey conducted by EU Commission in 2015, the respondents of the survey answered 60% of the respondents did not take any action to resolve their most recently experienced problem. The reasons are, first, sums involved were too small. As you know, e-commerce is most of e-commerce transaction is arising out of low value and high volume. So it's quite difficult to take an action against the trader for consumers. And respondents did not expect to receive a satisfactory solution. And third, they expected that any resolution would take too long. It takes too long. So the result from this survey, I assume, is time and cost to resolve online e-commerce disputes. And approximately 2/3 of respondents who took action were satisfied with the way their complaint was handled. It's quite interesting result, 2/3. And as regards dispute resolution method, 68% prefers out of court this dispute resolution, whilst the lowest 54% was in court. That means when as e-commerce evolves and innovated, court system will not be preferred by consumers and traders because of time-consuming and cost generating dispute process. So I will introduce three important international dialogues. First one is OECD. OECD was a sort of pioneer to generate this topic into the chapter of dialogue into the world. On December 1999, OECD guidelines for consumer protection in the context of e-commerce was published. And in chapter 6, entitled Dispute Resolution and Redress, they deal with consumers' accessibility to ADR and redress without unreasonable cost. That's it. That means they didn't deal with consumer protection and dispute resolution process in detail, just sort of like a declaration. And on July 2007, OECD published OECD recommendation on consumer dispute resolution and redress 2007. This is a little bit more developed international instrument. And common principles for dispute resolution and redress in B2C transactions. And in chapter 2 of the recommendation, it set forth about the provisions on domestic disputes, and chapter 3 for international disputes. And 2 years ago, last year, March 2016, they finally published about consumer protection in e-commerce and OECD recommendation in Paris. And they did not define what ODR is, but they mentioned it as one of the ADR method firstly. As you know, OECD is composed of 35 leading countries, but they don't have any enforcement authorities to enforce those instruments. That's the drawback. While I researched on ODR system throughout the world, EU was so impressive. And I think EU is a leading country to develop ODR system. EU in 2010, they set up the digital agenda for Europe. And this is a leading initiative of Europe to 2020. And they announced strategies to improve ADR system from 2010. EU was late comparing with OECD, but now I think it's a leading organization. In 2011, EU Commission communication, they also published Single Market Act in 2011. It provides a fast and low cost out-of-court solution between consumers and traders to protect the relationship between them. And 2013, they announced two instruments about EU directive on consumer ODR and EU regulation on consumer ODR. Those two instruments are very affecting on other international institutions to initiatives, including ASEAN and UNCTAD, UN. And in 2016, surprisingly, they already commenced EU ODR platform. And for the first year, they received more than 200,000 cases throughout the EU continent. That was surprising. This is my analysis of the EU ODR platform. 292 ADR institutions located in EU continent in 26 countries already involved in this ODR platform, powerful platform. So as you can see, UK, 42 institutions involved, and France, as you know, France and UK always are competitors each other, like Korea and Japan. And France, 41. And Denmark, Italy. And I think the number of these involving countries will dramatically growing. So I will show you, if I have a time, to the EU ODR platform directly, but I will briefly explain the procedures. The procedure can be divided into 4 steps. First step is submission of complaint, and second step is agreement on dispute resolution body. You can see the 292 institutions involved in this ODR platform. And then third step is dispute handled by the dispute resolution body. And last one, outcome of the procedure. So if you have filed in the online complaint form, not submission of paper, and submit it to this site, ODR, EU ODR platform, and then submit, the other party has received it, and you will now need to agree with the other party on the dispute resolution body, which institution will settle their problems. That was handle your dispute. You have 30 days to do so. So you have 30 days to negotiate directly between traders and consumers. And if you need help, you can contact your national contact point. So EU ODR platform designate all the national contact point of 26 countries. And then you move on to the next step, and you have 30 days to agree with the other party on the dispute resolution body that will handle your dispute. Once you do so, this site will automatically send the details of your dispute to that body. You designate the institution. And if you cannot agree, your complaint will not be processed further. If you need help, also you can contact your national contact point. The third step is dispute handled by the dispute resolution body. Okay, the dispute is already sent to the dispute resolution body. Then the dispute resolution body has 3 weeks, only 3 weeks, to decide whether it is competent or not to deal with your dispute and inform you thereof. It may contact you for more information also. And last one, outcome of the procedure process, that step. Once the procedure is over, the dispute resolution body will inform you of the outcome. This outcome varies per dispute resolution body. And I cannot find any statistics on the outcome from the EU ODR platform, but I expect they will announce any result. Then it would be very interesting. And third one is, I think this is the most recent talk at the level of international organization. It was conducted by United Nations, especially UNCITRAL. The first model for ODR platform was package model of the UNCITRAL draft rules on ODR process. So if buyer and seller will make a sort of like a contract on e-commerce website, then they can make an agreement which dispute resolution mode will be deployed. So when dispute arises, ODR administrator make both parties to make a negotiation each other directly. And then if they settle between traders and consumers, they settled. Then, of course, end of proceedings. But fail. Facilitate settlement will be conducted. That means mediation, which will not have any legally binding force between the traders and consumers. And if not settled, it goes automatically arbitration. So negotiation, mediation, and arbitration, this goes through at one time. This is called package model. But there was a controversial dispute among the participants coming from all around the world, because there was a dispute on what is the consumer, especially consumer arbitration is possible or not. I will explain on that point in the context of Korean regulation later on. So China proposed another ODR process strategy. This is the same to this steps. And negotiation and facilitated settlement is conducted at the same time. And ODR administrators' guidance on options, what is next if they fail to negotiate or agree to mediated proposal. Arbitration or recommendation by a neutral. That means, would you agree on the recommendation by a neutral, who involved in facilitate settlement process in this process? Or if you want to make us another arbitration agreement, and then you go to arbitration. That is China's proposal. The drawback of this strategy is there's no decisive solution to solve their problem. And EU also proposed another ODR process. Well, seller and buyer, they make a conclude of sales or service contract when they make a contract. Dispute resolution clause is in that the contract, and buyer has a right to click what he wants. And the buyer they can choose. Stage one is direct negotiation, and second stage is facilitate settlement. And then dispute will not resolve. ODR administrator can guide both parties also. Neutral recommendation or arbitration, you can choose among both of the mode. But the difference between China and EU's proposal is default option, default rule is neutral recommendation. That means if the parties will not agree on the last mode of dispute resolution, neutral recommendation is first. So this is analysis of those four proposals. First, draft rules of Unsistrol, track 1. Time of arbitration agreement and its validity and features. I can explain separately. So if a pre-arbitration agreement was agreed, the process will go through the arbitration automatically. 3 steps automatically. And no different approach in pre-arbitration agreement. And no problems can happen when deciding consumers or buyers' nationality pursuant to governing law. So ODR and e-commerce transaction disputes can generate 3 very important factors to think First one is private international law. Forum. Which country will be the forum? Or which country's law will be the governing law to govern their contracts? And EU, it requires a subsequent arbitration agreement for consumers from a state listed in annex or a buyer from buyers who are located in certain states. That means in Korea, we have the act, Korea's Act on Regulation of Terms and Conditions, 약관규제법. Article 14 prohibit unreasonable jurisdiction is prohibited. So this is the biggest obstacle for Korean governments and Korean arbitration community to adopt this ODR process. Second one is there is no any specific regulation setting forth on ODR process. ODR is permissible or not. Arbitration law of Korea is silent. So in Bangkok in July, I suggested eight recommendations. First one is align consumer protection laws. As you know, ASEAN consists of 10 member states, and their level and content of provision of consumer protection laws are various and different. And develop ADR redress schemes. And I will share a very interesting practice on e-commerce dispute resolution. PayPal or eBay and Alibaba, they have also their own arbitration clause in their website. And in case of PayPal, in 2010, they dealt with more than 60,000 million cases through their website. And some big companies have a trend to make a contract with a law firm to solve their own disputes. So if consumer arise any complaint on the website, they don't have to pay anything. Instead, the company should pay like $5 or $6 per case to law firms, which make a exclusive contract. So this will change the scheme of solve disputes for law firms afterwards. So we need to develop a two-track ODR framework. First one, Alibaba or Amazon or other big cases should solve their problem. That is the first one track. And mostly those cases will be dealt with by law firms, not their in-house counsels, because of reputation and impartiality. So that will make another chance of a market for law firms. And find a solution to employ availability of consumer arbitration. As you know, arbitration law of Korea was revised last year, but I think very soon we need to revise again, because our arbitration act is quite behind the trend and the level of development of arbitration now in the world. And we can also utilize the RCEP. You know RCEP. ASEAN 10 countries and Australia, New Zealand, and Korea, they are making dialogues in Incheon, Songdo now. And I think, as far as I know, they will include another chapter on e-commerce. Probably ODR network will be discussed together. And we need to enhance the awareness of consumers and campaigns. That means, well, this is another solution to solve. Well, due to time constraint, I will finish my presentation now. And then if you have any questions later on, I will answer for that question. Thank you very much.
Thank you so much for your wonderful presentation. And next speaker will be Attorney Kim. Please take the floor.
Hello, my name is Kim. I'm attorney in law in Xi'an Law. Before joining Xi'an Law, I worked for an entertainment company. And the company had some legal disputes with Chinese artists. So at that time, I gathered some cases related to Chinese entertainment dispute resolution. And I asked the Chinese lawyers' advice. Today, based on the results of the review, I would like to briefly present the current status of ADR, including arbitration related to entertainment in China. And let's look briefly at the ADR regulations. And I will introduce 5 cases related to entertainment. All cases are related to exclusive management contract in entertainment field. And from the first to fourth are ADR cases, but the 5th is a court case. But it can be considered as a precedent to understand the Chinese basic judgment of Chinese court. So I will introduce that. And let me briefly review the current status of ADR related to entertainment in China. Finally, I would like to talk about how to resolve legal disputes related to entertainment in China. According to China's regulation, it is not very different from our country's laws. Let's take a look at arbitration law. First, the arbitration law is formulated to ensure that economic disputes shall be impartially to properly arbitrated to protect the legitimate rights and interests of the relevant parties, to guarantee the healthy development of the socialist market economy. And disputes over contracts and property rights and interests between citizens, legal persons, and other organizations as equal subjects of laws may be submitted to arbitration. But disputes over marriage, adoption, guardianship, child maintenance, and inheritance and administrative disputes are not matters to be arbitrated. And as you know, for arbitration, it is necessary to have arbitration agreement on a mutually voluntary basis. And the following contents shall be included in an arbitration agreement. First, the expression of parties' wish to submit to arbitration, and the merits to be arbitrated, and the third, arbitration commission selected by the parties. And the single ruling system shall be applied in arbitration. And there are many arbitration commissions in China. Arbitration commissions may be established in the municipalities directly under the central government, where the people's government of provinces and autonomous regions are located, or, if necessary, in other cities divided into districts. And the China Arbitration Association shall formulate the arbitration rules. And there are some foreign arbitration commission in China. For example, CTEC in Beijing and SYKim in Shanghai. Foreign arbitration rules may be formulated by the China International Chamber of Commerce. And as most of you know, China joined the New York Convention on April 22nd, 1987. And besides arbitration law, there are some regulations like civil procedure law of China, like reconciliation and mediation. In foreign civil cases, the People's Court shall mediate the disputes according to the principles of voluntariness and fairness. The mediation shall be effective immediately upon signature by both parties. From now on, I'll introduce some examples of entertainment disputes in China. The first is the case between Chen Chusong versus Tianyu. Chen Chusong is a Chinese singer, TV program 2007 winner. Tianyu is a celebrity management company in China. In July 2007, the exclusive management contract between Chen Chusong and Tianyu was concluded, and a bilateral dispute occurred in 2009. So Changsha Arbitration Commission made arbitration award like this. The commission ordered to terminate the exclusive contract between the parties. There were damages awarded to TNU in the amount of 6,500,000 yuan. By the way, TNU has applied for the cancellation of the arbitration award to Changsha Intermediate Court. As a result, the part of arbitration award was invalidated. The reason for the nullification was that 6 million yuan exceeded the scope of the arbitration agreement. After nullification of the arbitration award, TNU sued Changsha Intermediate Court for damages. The court rules in favor of TNU awarding damages in the amount of 9,500,000 yuan, but the judgment was appealed by both parties, and at last non-trial settlement was made during upper hearing in 2010. And next is the case of a dispute between He and TNU. He is a Chinese singer too. TNU, a celebrity management company in China. This case was arbitrated by the Haegu Arbitration Commissions. The arbitration tribunal finds He's abandonment of the contract to constitute a fundamental breach. TNU is compensated by an award damages in the amount of 800,000 yuan. It's a very short story. Next is the Arirang Group's case. Arirang Group, a group of men composed of 4 Korean Chinese members, and Myeongjun is an entertainment management company in China. 2005, the exclusive entertainment management contract is executed. And after about 2 years, Arirang Group files a lawsuit. The group demands disclosure of Myeongjun's register of income, and penalty payment and damages for economic loss. And Myeongjun files a counterclaim against Arirang. Myeongjun demands penalty payment of 1 million yuan and continued contractual performance of the group. Finally, a settlement agreement was concluded with the court. The content of the agreement is very specific and detailed. Arirang is to make the following payments to Myeongjun as damages for termination of contract, like this. If Arirang fails to pay the damages above in a timely manner, the penal interest rate during the period of delay will be 4 times the interest rate at 6 months loans of the People's Bank of China. I'll skip number 3. And Both parties waive the right to claim damages for breach of contract committed by the other party prior to July 2nd, 2007. If Arbitration fails to pay 600,000 yen before January 1st, 2008, Arbitration shall continue to be bound by the exclusive contract. The first case is Shang Wenji vs. TMU. Shang Wenji is a Chinese singer, a Hunan TV program winner. TMU is an entertainment management company in China. An exclusive entertainment management contract was executed by the parties. Shang Wenji applies for arbitration. Shang Wenji files a claim for termination of the contract on the basis of inequality. TMU files a counterclaim for damages in the amount of 8 million yen. And unless the contract was terminated under the mutual consent after Shang Wenji paid a certain sum of damages to TMU. As I said, this case is a court case. Dojo, a Chinese entertainer, Beijing Pictures, an entertainer management company in China. In 2010, an exclusive entertainer management contract is executed. The company is to provide business consultation and guidance regarding all entertainment activities of Dojo, enter into contracts on Dojo's behalf, and receive 30% of the Dojo's earnings, and Dojo shall not enter into any entertainment contract with another party. But Dojo participates in 59 entertainment activities without the consent of the company. And Dojo notified the company of termination of the contract and requested the court to confirm the nullification of the contract. Dojo claimed that the company had improper contractual performance and had the unilateral right to terminate a proxy agreement or brokerage contract. On the other hand, the company files a counterclaim for breach of the contract by Dojo. And the court did not find the contract that issued to be a proxy agreement or brokerage contract, but rather to be a contract with a complex nature, which does not endure one single party with the unilateral right to terminate the contract. Because the management company bears a certain amount of risk in bringing up an entertainer, the court found that if such unilateral right of termination are acknowledged, first, the management company would be placed in an inequitable position to engage in contractual performance. Second, the doctrine of good faith and fair dealing would be violated. And the third, it might incite the entertainer to seek termination of contract in bad faith for pecuniary gain after gaining fame. Accordingly, the court found that placing a limit to the practice of the unilateral right of termination was reasonable under the circumstances. But as Dojo clarified its intentions not to continue performance of the contract, the court issued an order to terminate the contract for the mutual benefit of the parties and awarded a compensation 2 million yen in damages to the company. Then is ADR used often or heavily? ADR seems to be widely used in the case of entertainment disputes in China, at least legal disputes related to management contracts. And in my opinion, the outcome of ADR in China, just like a court trial, hinges mostly upon the fact as to which party failed to comply with the contract. This is in contrast to the fact that fair trade issues are very important in Korea's entertainment disputes. And these are statistics and types of international cases accepted by the CTEC in 2015. 35% are selling goods, 50% are electromechanical equipments, and entertainment sector is not recorded. Perhaps the entertainment sector is likely to be included through service contracts or intellectual property rights or agency contracts and so on. The reason for this is not that arbitration in the entertainment field is not used very much, but rather the entertainment dispute itself is less than the case of other sectors like selling goods. In general, entertainment disputes are characterized by these. The disputes often relate to sensitive and emotional issues. The disputes are prone to involve international issues. The longer the dispute goes unresolved, the more extensive the damage is likely to be for both parties. So, as an entertainment dispute resolution method, it appears that the arbitration procedure has many benefits because various types of dispute resolution are available, and enforcement issues can be resolved because of New York Convention, and it is very quick because of the single ruling system. So, arbitration procedure in China can be a very effective dispute resolution in entertainment-related disputes. This concludes my presentation. And please note that the arbitration cases I introduced today are summarized by Chinese lawyers in the Chinese press, not publicly issued, so maybe partially inaccurate earlier.
Thank you. It's time for me to just introduce some legal system. I'd like to introduce some enhancement process for the credibility of the enhancement of credibility of arbitral award. Recently, I visited the ICC court arbitration court, and I was very impressed when I met the managing counsel, who is Philip Jiva, who is the attorney, and she explained about just the systems, internal review system of the ICC. As you may be aware, ICC is one of the leading arbitration institutions, and I'm more focused on the strict scrutiny process in rendering the arbitral award. And the background is like we compare the arbitral award with the court judgment. There are some distinction between both of them. One is one ruling system, is one-time penalty. Court system is 3 levels: district and appellate and the supremes, and therefore the credibility is secured compared with the arbitral award. It means like court judgment judgment is rendered by the professional judges, and also 3 levels scrutiny process, and also judges standing job, and the arbitrators is like not standing, just it will composed on case by cases, and also some arbitrators are not legal professions, and therefore the most important thing is credibility of the arbitral award is very important, and it is very essential in terms of vitalization of arbitration industry, and also enhance the competitiveness compared with the court judgment, and also how can I say, just the establishment of judgment. And unfortunately, we do not the arbitral award process do not have many correction process available. Yeah, in some arbitration process is some correction process also available. Some of them are just composed of appellate structures, but most of the arbitration process is just only one time, one ruling systems, and therefore is sometimes a little just reluctant to go to the arbitration institutions, and therefore enhancement of credibility of the arbitral award is very essential. And in this regard, I think ICC model is one of the just reference materials, models, which we refer to. First of all, I'm just a little surprised. Two things. One is annually 1,000 new cases, and currently is pending cases 1,500 cases in arbitration, ICC arbitration court. And the second thing is the amazingly, the average amount in dispute per case is $100 million. This is a lot. It's almost 100. This means like it's $100 million. And yeah, maybe just at the first when I heard what the managing counsel in ICC told me, I was surprised. But yeah, she explained to me just some cases which the actual dispute amount of which is less than 1 billion is around 30% of all cases ICC, but some of around 90 cases per year is the dispute amount in each case is $500 US, and therefore the average amount in dispute is $100 million US or more, and therefore the enhancement of credibility of ICC arbitral award is very important, and also they play a major role in the international dispute, because annually around 1,000 cases, and also dispute the amount for each case is $100 million US, and therefore it's like but still that's the only one time, one ruling system, and that is final. There is no appellate layer, and the court does not have any room just to intervene the merit of the arbitral award, and therefore this is a very important issue. And I just today is like maybe there are some very publication about these issues, but I briefly explain to you. Normally, in our cases, trivial cases, it's like for each cases, maybe sole arbitrators and 3 arbitrators. Normally, in this cases, it's minor cases, and or just they tried the parties wanted to go into the fast track. Otherwise, maybe just big cases like tribunal members are composed of 3 arbitrators, and just after the pleadings, and they just they prepare the arbitral award, then just directly go to the parties. But in ICC cases, it's a little different. If a tribunal members prepare the draft of arbitral award, then it should be just sent to the secretariat personnel, and they review it and sanction the formality in terms of formalities and the substance. And but they say some conclusions, but they think that there is not some sufficient analysis. Then they make some comment, and then they prepare some internal memorandum along with the draft arbitral award. It will be sent to court counsel. Court counsel is composed of some kind of famous arbitrators and international law professors, etc. It is the term of counsel is 4 years, and but they do not have any remunerations. They do not have any compensations. But they review, and based on the memorandum prepared by the secretariat personnel, along with the draft of arbitral award, they review and some comment. This will just be sent to the tribunal members, and the tribunal members will review the memorandums, but they are not legally bounded by the comments by court counsel or secretary personnel, but they will definitely respect, because they make some mistakes and some calculations and also formalities and etc. etc. And then finally, during this process, this is 30 parties, tribunal members, secretariat personnel, and the court counsel. Then finally, tribunal members will send the final arbitration award to parties. But this is a very important process because internal strict scrutiny process to enhance the credibility of the arbitral award, because in terms of amount, dispute amount, etc. And also enhance the credibility of the arbitral award. And this is quite interesting. And also, in that regard, SEAC, Singapore International Arbitration Centers partially adopted, but it's not, it's kind of partially and not officially. And therefore, I think anyhow, this is ICC strict scrutiny process in order to enhance the arbitral award. The credibility of the arbitral award is very very impressive model, which we may refer to in just enhancing to enhance the credibility of the Korean arbitral award in Korea. And because constructive adoption of the ICC model is very important in terms of vitalization of the arbitration industry and the acquisition of the credibility of the arbitral world among the legal profession, world, and also public, from the public. And now we may be just more some research, conduct research in this regard is very important. Otherwise, it's currently we just enacted the special law on the promotion of arbitration industries. In this regard, this kind of process will be important. And this regard is two trade paths. One is IC is to not deal with consumer type of dispute, which is just a kind of standard dispute, and also the dispute amount is low. But this is a big cases, and we have two tracks. One is this kind of international big case, and some typical consumer type of dispute. And in these areas, ODR will be also widely applied in the near future. And this process is a little different. The big cases, they prepare, the parties prepare the face-to-face hearings and all this kind of process. They take about, they need more just consulting. Therefore, in Korea, it's like the representative arbitration institution is like Korean Commercial Arbitration Board, maybe just partially adopted this kind of ICC model, and also just they from some assistance from the government, maybe just for the consumer type of dispute, maybe ODR model will be adopted, and that is a little maybe that is my impressions, and therefore I just briefly introduce the state security process of ICC, and just I finished my presentations, and now just we start just Q&A sessions. If you do you have any questions on floor, and please give me answers. And this is we do not have a panel tables, and but more to just make an accurate response to your inquiries, and anyone ask any questions, then just the speakers, the relevant speaker will just respond to your questions. Do you have any questions? I'm just a kind of moderator. So I'm just a little questions, but I'm not sure whether or not my understanding is correct. But according to your cases, Attorney Kim, just some arbitral award, the partial is nullified by the court. It is in Korea it is not possible. But how would you just explain, or if you need more detailed explanation, maybe just later on it's possible. But I was just wondering how the court. How can court involved in the just nullification, partial nullification of arbitration award? In Korea, it's like arbitral award is a violation of the public order. We definitely will be partially will be nullified. But would you just explain about that? It's the same kind of partial nullifications, because like the amount of how can I say? The damage is too high, and it's a kind of violation of the public policy, and maybe it includes, for example, if such damage includes some punitive damage like characteristics, then maybe it can be partially nullified. In Korea, we have some cases. Some is the foreign arbitral award. Or just it is an arbitral award cases, but this court judgment, U.S. court judgment, this is they include some kind of punitive damage amount, then it's partially nullified. Anyhow, maybe
I guess the contents of arbitration agreement, because of contents of arbitration agreement between them, okay, so they limited the merits, limit the merits by arbitrating until 500,000 yen. Okay.
Yeah, but anyhow, the literature is not quite. Sometimes, for example, in Hong Kong, it's like some labor dispute administrative court. They do not allow any how can I say, assistance from the lawyer, and it's very strange. It's administrative court cases, but they do not allow any lawyer to be involved in this case. It's because, but it's the reasons behind them is just it's like normally it's like the company and some laborers, and the companies will be able to, it's like very good lawyers, but compared with that, laborers, they cannot afford it, and therefore it's like it apparently it looks like strange, but administrative court cases, they do not allow any lawyers. But in that regard, possibly I think that the court, maybe I'm not sure, but it's basically the court was just maybe my understanding is not correct. Possibly, yeah. So you're saying is the arbitrate, the contractors, they have some kind of limitation? What? Yeah, but if you need more detailed explanations, maybe later on, just say some kind of address, and therefore you give me some answer. But basically, yeah. But apparently, it's like it looks some is familiar to me, and therefore I just raise some questions. But possibly just the court will involve the arbitral award, if the arbitral award is like contains some include some kind of punitive damage type like damage, then will be just some partial annulment or nullification of the arbitral award will be possible. Do you have some answers? Later on, would you just give us some detailed explanation? Or okay. Do you have any other questions? If not. I just finished our presentations. Thank you very much.
I would like to express special thanks to the three speakers who delivered a wonderful presentation today. Once again, please give a round of applause to the three speakers. Now it is time for us to close the seminar of Asia Pacific Arbitrators Forum. We truly appreciate your time and attention of all the participants in the seminar, including the three speakers. Thank you.